Welcome everyone to today's webinar, Proposed Sexual Harassment Prevention Policy Updates, presented by Michael Schiatti and Ariana Kayatowski with Barclay Damon. Many thanks to our presenters, Michael and Ari, for joining us today, and all the participants who have joined in this seminar. Michael and Ari will share their presentations with you, then follow with time for questions and discussion. With that said, I'll turn it over to Michael to start things off.
Hey, good morning, everyone. Thank you for that. Ari and I have a lot to go over with you today, and we will announce that this is no longer proposed.
Nice. Very good.
It is no longer.
But by me saying that.
Beth, can you hear me?
Yeah, I'm just muting some of the participants.
Okay, no problem. So we'll start with these are no longer proposed. They have a final, the updated policy. In the handouts, we have provided a copy of the new model policy, which we are recommending that companies complete, have all your employees, distribute to your employees, and have all employees sign off on. You must complete the policy. There are blanks in it. And if you simply take the blank policy that we provided, or you take it off the state's website, you're doing yourself a disservice without filling it the rest in. So please be aware of that. We also decided to present the additions within the context of the overall of the program itself in that regard. Please note that the materials have been provided in the chat, both the model policy and the PowerPoint itself. So with that, we got a lot to go through. My contact information is here. Both Ari and myself are on social media. Here's my Twitter. Here's my LinkedIn. We post quite a bit. Here is Ari's contact information and her LinkedIn as well. Also, Ari has spearheaded the firm's labor and employment podcast. I highly encourage you to listen to this. They're short tidbits of updates in the law and easy to listen to online, and it's a great way for you to stay up to date. In addition, we also do something for similar in the cyber world, where another one of our partners, Kevin Sapansky, handles everything you need to know about the evils of cyber and the legal ramifications of it. So our agenda today is fairly aggressive. Some of it is old stuff, meaning it didn't change in the law. So some of it we might fly through a little bit. We will try to point out where the changes have occurred. If you've done the sexual harassment training, please note that the new regulations still require that you do it every single year for all employees, without exception. Every year, all employees. So our agenda today is we're going to talk about general harassment concepts and who can harass who. I'll cover those first two. Ari will cover the next four, talk about the policy requirements that are out there. Talk about supervisory responsibilities, investigation obligations, and bystander intervention. I can tell you in every bullet point that we have placed here, there is new information that the state is requiring you to train on. Some of this stuff, I will be frank, you'll laugh at because it's like, really, did you need to say that? Well, apparently they think they did. In that regard. So it's here, whether you like it or not, we'll inform you about it. The good news is, what is sexual harassment? Not a lot of updates in that. I'll go through that with you. We'll talk about the hostile work environment, really no changes to quid pro quo. A lot of changes in retaliation. They gave us a lot more information, a lot more examples in that regard, and Ari will handle that with you. So let's start with general harassment concepts. You need to train all your supervisors. If they get a complaint from an employee, how can I help you? They don't need to respond to it. They don't need to act with it. They need to make sure the employee is safe in that regard. Don't send them back to work if they're complaining someone just sexually harassed them. We make sure that we take the problem up the chain of command to whoever that may be. There are some supervisors we do not want handling anything to do with sexual harassment. I think you want to centralize the complaints as best you can and have a person who's properly trained and knows how to investigate. But the supervisor, how can I help you? They can think whatever they want about the employee, because let's be honest, some of your supervisors have employees they love and they hate, and everyone in between. How can I help you are the exact words I want to hear come out of their mouth. The objective of the training, the objective of the policy, the objective of the complaint form is to stop sexual harassment. I have yet to meet anyone that thinks that's a bad thing at the end of the day. So, that's why we're doing this. Here's some new stuff that they put in the model policy. Sexual harassment is unacceptable. I said, really? You really thought we had to add that to the policy? Of course it's unacceptable. Any employee or covered individual. Now let me stop there. Please remember in the slides that follow, this applies to anyone entering your workplace, okay? So it's not just your employees anymore, it's anyone they're interacting with, and they don't even have to enter your workplace. It could be a customer over the phone sexually harassing them. You have to intervene in that regard. Well, Mike, how are we going to know about it? Well, hopefully they complain at the end of the day. So any employee or covered individual who engages in sexual harassment, discrimination, retaliation, or any illegal conduct is subject to discipline. All right. Now, does the employer have to fire someone that is engaged in sexual harassment? No, they do not. Sometimes it's a misunderstanding. Sometimes an apology is acceptable and ends it. You just got to monitor it in that regard. But you have the full gamut available to you, from a verbal warning to a written warning to a suspension without pay, a suspension with pay, which I'm not a fan of, a last chance agreement, make them go to counseling in conjunction with some type of suspension. I'm doing one-on-one with the chief operating officer who is naughty in that regard, and we put him on the last chance agreement. Don't be afraid. And then there is the death penalty, what I call termination. Don't be afraid to terminate in that regard, but try to make sure your policy determinations are consistent in that regard. The severe or pervasive standard that exists under federal law does not exist under state law. One thing is enough in that regard. Employees should not feel discouraged from reporting harassment because they don't believe it was bad enough, or because someone was joking in that regard. As you're going to see, supervisors have an absolute obligation, but we want to strongly encourage employees to complain about sexual harassment. Also, sometimes we see employees, I don't want to get him in trouble. Supervisors, too bad, you must intervene and act. And your rank and file employees, we want to encourage them to come forward. We can't stop the harassment unless we know about it. As I mentioned, the counseling the discipline could include education and counseling. It doesn't have to be a termination. There are some things that are so over the top. You're going to fire, and there are some things so over the top, you're going to call law enforcement. Don't be afraid to call law enforcement. Law enforcement is your friend. If an employee has been sexually assaulted, please call law enforcement. The investigation, the internal stuff that we're going to do is secondary to the crime that has been committed. Please never be afraid. And if you're wrong, it's okay. The cop will tell you no crime has been committed here. But at least you know that. So if you're ever challenged, why didn't you call the cops? I did. They told me there was nothing they can do. Here's the police report, incident report, closing it out, where they said there was no criminal conduct in that regard. And then we'll do our internal investigation. And some of you have supervisors who are ostriches. They don't like conflict. They don't like interacting with the rank and file. I think you need to, quite frankly, reevaluate them. If there are employees that can't handle the supervisory responsibilities that Ari is going to go over, they can't be supervisors. Part of this training is for you to reevaluate your supervisory force. If they can't do what we're telling you to do, they can't be supervisors because they're a walking piece of liability. Supervisors can bind the company in that regard. I want you to have a let them complain attitude. Thank you. May I have another? The only way we can stop inappropriate conduct, harassment, discrimination, retaliation, whatever it is, if you create an environment where your employees want to complain and are not fearful of the complaint. So please encourage that as best as you can. Give them as many avenues of complaint as possible. Some of you have these hotlines. Make sure you give out contact information for individuals who are going to be receiving complaints in the workforce. I want their cell phone number, their email, make sure they feel comfortable and have lots of avenues to complain. Once we complain, there will be an investigation. Ari will talk a little bit about the investigation. It's a whole nother course, how to investigate claims of sexual harassment. We're going to do just a little tidbit today. Basically, you got to investigate. What that investigation entails differs from case to case. We would be remiss if we did not point out that there's lots of forms of discrimination here in New York. It could be age, race, disability, color, national origin, sex, family status, marital status, etc. I didn't list them all. We only have to train on sexual harassment. I would encourage you to develop a broad training program for your employees to sort of educate them on everything else. And some of the training is only for supervisors. So we do this course for supervisors as well. And it's funny, it's the same set of slides, but I come at it at a totally different angle in that regard. One of the things you want to encourage your employees to do is follow the policy. The same thing with your supervisors. Make sure they know what the policy is, make sure they know what they're supposed to do in that regard. If you have disciplinary actions, please make sure they're consistent as best you can in that regard. And this means you. I do training all the time. I'm doing it this afternoon as well for a client. And I tell them, don't joke about this afterwards. 10 minutes later, I've all packed up. I'm going to the restroom. They're in there joking about it. They don't get it, some people. This means you need to hit that home with some people, because there are people in your workforce that don't get it and they think they're above this. One of the things you want to encourage is space, respecting people's boundaries. If someone tells you they're uncomfortable, the employee needs to back off and not do it again in that regard. A lot of problems occur because of violations of personal space. Some problems occur in this area where I'm joking with you and you're joking with me, but a third party overheard it and they're the ones that offended. We bring those two employees in, they say, well, yeah, we did it, but we weren't offended by it and it wasn't directed towards her. Not a defense. That conduct has to stop in the workplace. Okay, who can harass who? They actually expanded this section and we'll hit some of the new things in a minute. Anybody, all right? Doesn't matter what the sex is, doesn't matter what their position is. They could be a customer or a vendor, an employee, etc. It simply does not matter anymore. And you need to realize now, a third party entering your workplace. So let's assume your receptionist sexually harasses the UPS guy. The UPS guy can now bring a claim against the company under New York state law for that sexual harassment. So it's a two-way street. It's anyone entering your workplace can harass your employees, anyone in your workforce, and vice versa in that regard. So it can be female, male, male, female, male, male. It makes no difference, folks. Now, this is some new stuff that the state has added, these next few slides. Sexual harassment doesn't happen in a vacuum, and in that regard, an employee can be impacted by biases and identities beyond an individual's gender. And they gave us some examples in that regard. Placing different demands or expectation on Black women employees than white women employees can be both racial and gender discrimination. If you do that, it violates our simple rule, treat everyone the same in that regard. An individual's immigration status may lead to perceptions of vulnerability and an increase in concerns around illegal retaliation for reporting harassment. So if you have an illegal, that means they got by your I-9, you have a problem that the I-9 was not successfully completed. You can't threaten someone, oh, you blew so-and-so in for sexual harassment. I think you should keep your mouth shut, because if you don't, we're going to see you're deported because I know you're illegal. That is illegal in the state of New York. Past experiences as a survivor of domestic or sexual violence may lead an individual to feel re-traumatized by someone's behavior in the workplace. New York has moved in the sexual harassment law. You take the victim as they come. It used to be a defense in New York. Yeah, they're overreacting to this situation. Not really anymore. One incident, and we're taking the victim as they come. We have this the standard, which you'll see later on, talks about a reasonable victim standard. The only thing that really is not covered anymore are trivial slights, and you're going to have the burden of proof in that regard. So remember, personal histories are being brought by your employees with them. You may have a victim of domestic violence. You may have a survivor of sexual abuse or sexual assault. And your employees have to be cognizant of that. Not that we're going to identify these people. That's not what I'm saying at all. What we're saying is, when you do your training, you need to get through to the individuals. They need to be mindful of this. So, words, actions could impact one employee more than another employee, and they just need to be aware of that. A lot of it is joking. People think they're being funny in that regard, and they're really not. And someone said, Mike, you're taking all the fun out of work. I said, Mike's not. The state of New York is creating a sterile work environment. They want no harassment, discrimination, inappropriate conduct of any way, shape, or form. Most workforces that flies, but it doesn't fly in all workforces. And I use these examples because they're at the other end of the spectrum. You got bars out there. I have a case, I'm defending a bar now. There was a lot of swearing going on at the bar, and everyone's like, seriously, this is a bar. We need to analyze this from that perspective. Other employers that I joke about over at the other end of the spectrum. What about a porn shop? What about a strip club where there are employees? These are the same rules that apply there. Difficult to get them implemented in some places, and just be cognizant of that. Most of the people on this call, it shouldn't be difficult. Okay, so with that, I'm going to mute myself and turn it over to Ari, who will handle the next, I think, 3 or 4 seconds.
Thanks, Mike. Can you hear me okay? Great. Good morning, everyone. We're 3 years into the pandemic, and I often find that I still fail to unmute myself when it's my turn to talk. So apologies about that. But as Mike mentioned, I'm going to start talking about your company, your sexual harassment prevention policy. Just taking a step back, obviously we're talking about sexual harassment today. But I think it's important to also talk about equal employment opportunity. I'm sure most of us on the call have an equal employment opportunity policy, and this is not new, but it's very important your company is an equal opportunity employer. Diversity is a strength. And what does it mean to be an what is an equal employment opportunity? Recruiting, hiring, training employees without regard to race, religion, color, sex, age, national origin, etc. I don't think this is, anything new, hopefully for most of us on the call, but we definitely wanted to point it out. So basically, your workplace has to be harassment free. There has to be a harassment free work environment, and your company has to be committed to maintaining a workplace in which all individuals are treated with respect and dignity, and every employee should be able to work in an atmosphere that promotes equal opportunity and prohibits unlawful discrimination. So what are we talking about here? I think this is really an emphasis on company culture. I think a lot of us on the call have spent time thinking about this. I think that this really means a top-down, no tolerance policy for harassment in the workplace. Your company cannot tolerate harassment for your employees at work by anyone. It includes by executives, supervisors, employees, or non-employees. So any contractors, customers, vendors, residents, etc., that may be on the property. And the fourth example here is not a new example for 2023, but it's something that doesn't come up quite as frequently, but we wanted to point it out because this really applies to, it's not just limited to your employees. It's important that you encourage your employees to report all information relating to workplace harassment, regardless of the identity of the alleged harasser or victim. And this is really important, and we're going to talk about this a little bit more in a couple minutes, but your company has to require that any supervisor who is aware of or suspects a violation of the policy to report such suspicions and violations. I think a lot of us on the call know that this is so important because supervisors can bind the company, their actions can bind the company. And your company should further also require any supervisor to encourage the employees they supervise or other employees in the workplace to report any violations of the policy. So basically, anyone who witnesses or becomes aware of potential instances of sexual harassment should report that behavior, whether or not they're a supervisor, a colleague, an employee, an intern, etc. The policy applies to all employees, to applicants, as I just mentioned, to interns, paid or unpaid. This has come up a couple times for us, but it's important to recognize that it's not limited to just employees that are paid. And as I mentioned a few minutes ago, independent contractors, vendors, consultants, gig workers, temporary workers, basically other persons that are conducting business with your company. And I think Mike may have mentioned something, I think Mike and I were talking about this offline, but immigration status is not relevant as it relates to the application of your policy. So a question we often get, do non-management employees have to report sexual harassment? So all employees in the workplace are encouraged to report any harassment or behaviors that violate the policy. So I think it's important, talking about company culture, when you're doing the training, to stress that, of course, the policy is here to prevent sexual harassment in the workplace. It's here for you as an employee in the unlikely event that you are a victim of sexual harassment, but it's really a no tolerance policy for everyone in the workplace. And you as an employee, if you witness something with your colleagues, should definitely report it. And of course, your company has to provide all employees a complaint form to report sexual harassment and file complaints. That's not new for 2023. The model policy under New York state law has always had the complaint form. But why is the complaint form important? Of course, because your company can't stop unlawful harassment in the workplace unless it knows about the harassment. And this is really important. Mike touched on this a few moments ago, but behavior does not need to be a violation of the law in order to be a violation of the company policy. In fact, it's good to have a company policy that has a zero tolerance a zero tolerance attitude toward harassment in the workplace. As Mike mentioned, that doesn't mean that every instance of harassment justifies termination or even discipline. It could be a misunderstanding or something to that effect, but it's important that we don't want behavior to get to the level of it being illegal for it to violate our policy. So, as I mentioned a couple minutes ago, it's important that the company provide employees with the complaint form. As we mentioned earlier in the presentation, you have a copy of the model policy that's been adopted for 2023, which does include the complaint form. But it should be clear to your employees that complaints do not need to be limited to the complaint form. Of course, if employees are more comfortable reporting verbally or in a different manner, it should be clear that they're free to do so. And of course, if your employees do report verbally, your company is still required to follow the sexual harassment prevention policy by investigating the complaint. So just because an employee does not fill out the formal complaint form does not mean that a full investigation or an investigation of the complaint is not needed. And in fact, the complaint form has to be completed. So that we wanted to point that out because, you know, some supervisors just hear things even, you know, in casual conversation. So it doesn't necessarily need to be a formal complaint form, you know, that's filled out. If you are an employee in the workplace and you report harassment to a manager and receive an inappropriate response, such as being told, just ignore it, I don't think he or she meant anything by it, you know, the policy should include other avenues for the employee to report the instance of sexual harassment. This is also important, and we're going to talk about this a little bit later when we talk about bystander intervention, because the policy for 2023 definitely has some updates that we want to point out for you. But anyone who witnesses or becomes aware of potential instances of sexual harassment should report it. We'll talk about this a little bit later as well when we talk about retaliation, but each report that's made in good faith is itself a protected activity. So if there's a report of sexual harassment to management, to a supervisor, et cetera, that is a protected activity under the law and under the policy. And we'll talk a little bit about that because the state definitely beefed up that portion of the model policy for 2023. So I think that's a good overview of your company. Again, can't stress enough, it's really a matter of company culture. You want to make sure that there is a top-down zero tolerance policy, or there's no tolerance for harassment in the workplace. And it's a good time for us to talk about supervisor responsibilities. There are some changes to this in the new policy as well. So as we've, I think, said a couple times this morning, managers and supervisors are required to report any complaint that they receive or any harassment that they observe or become aware of. So formal complaint, if they see something in the workplace that seems kind of suspect, or if they become aware of it and not even necessarily through the alleged victim or the alleged harasser. Everyone has to work toward preventing sexual harassment, but as we stressed, leadership, of course, matters. Supervisors, managers have a special responsibility to make sure that employees feel safe at work. And we really can't stress this enough. It's not just, of course, a zero tolerance policy for a supervisor to commit sexual harassment or harassing behaviors in the workplace, but there really has to be a zero tolerance policy for anything that the supervisor or manager observes or becomes aware of. And managers and supervisors should not be passive and wait for an employee to make a claim of harassment. If you have a manager or a supervisor who observes such behavior, it has to be clear to them that they must act. Can't stress this enough, because as we've discussed, you know, the actions of supervisors, managers, or inactions of them could bind the company. So this is new in the 2023 policy. Basically, the state has said, while supervisors and managers have a responsibility to report harassment and discrimination, supervisors and managers must be mindful of the impact that harassment and a subsequent investigation has on victims. And the policy says that being identified as a possible victim of harassment, questioned about harassment or discrimination can be intimidating, uncomfortable, and re-traumatizing for individuals. So basically, the state is saying you have to take a step back. This isn't just necessarily as a supervisor checking a box, receiving a complaint, reporting it up the chain, investigating, et cetera. there really has to be some consideration on behalf of the employer or the company for the impact that reporting this harassment or being harassed has on the potential victim. So this is definitely new for 2023. Supervisors and managers have to accommodate the needs of individuals who have experienced harassment to ensure the workplace is safe, supportive, and free from retaliation for them during and after any investigation. This I don't think is particularly, this I think didn't necessarily need to be said. I think we've come across situations where there's been egregious or even maybe not egregious conduct. And, it's a lot of times we have our clients who, separate the two employees while they're investigating it. As Mike mentioned, there's paid, unpaid leave, etc. But again, under the supervisory responsibility section of the new policy, supervisors must report harassment they observe or know of, even if no one is objecting to the harassment. So if your supervisors, your managers see something, it's on the borderline or it's in the realm of harassment, it's just, they must report it. If a supervisor or manager receives a report of harassment, it must be promptly reported and it's without exception for supervisors and managers. So I think Mike and I have been in trainings that we've done even before 2023 or the new policy, we've really stressed this, but it really can't be stressed enough. And the supervisor has to act even if they think the conduct is trivial or the harassed individual asks that it not be reported. So it really is, if you see something, you have to say something. I think it's important that supervisors and managers know that if they fail to report suspected sexual harassment or otherwise knowingly allow it to continue, that they will be subject to discipline. And of course, they will be subject to discipline for engaging in any retaliation. And we're going to definitely talk about that in a few minutes. So let's talk about the investigation. A supervisor, a manager, an employee has made a report of sexual harassment. What are your obligations in terms of an investigation and any corrective action? All reports of sexual harassment, whether information was reported in verbal or written form, as we talked about a few minutes ago, have to be completed within a reasonable time frame. And of course, I think it goes without saying that it should be confidential to the greatest extent possible. And I think that's usually, of course, the case for any investigation of a disciplinary issues. Does your employee have an obligation to cooperate with a sexual harassment investigation? And of course, the answer to that, I think, as we all know, is yes. All employees, managers, supervisors, etc., are required to cooperate with an internal investigation, and your employees should be aware of that. Obviously, with respect to discipline, we talked about this a couple times this morning. Employees who are found to have engaged in harassment will, of course, be subject to disciplinary action, which could, of course, include termination. So obviously a case-by-case basis. As Mike mentioned earlier in the presentation, it just because someone has engaged in sexual harassment does not necessarily mean that discipline has to be termination. But definitely it should be clear that disciplinary action will ensue if there is an issue of sexual harassment that is found to be substantiated through the company's investigation. So let's move on to bystander intervention. This is something that is definitely different for 2023. And some of the examples provided are a little bit, I will say, out there, but we're going to talk about them and we'll definitely work through them. So generally, an employee witnessing sexual harassment, any employee as a bystander is encouraged to report it. And of course, a bystander that's a supervisor or a manager must report it or is required to report it. So this is new for the 2023 policy. Basically, the state has said that there are 5 standard methods of bystander intervention that can be used when anyone witnesses harassment or discrimination and wants to help. Number 1, a bystander can interrupt the harassment by engaging with the individual being harassed and distracting them from the harassing behavior. So basically, I guess this says that a bystander can try to kind of break it up or distract from the situation. A bystander who feels unsafe interrupting on their own can ask a third party to help intervene in the harassment. So someone else who may be in the room, a supervisor, a manager, somebody who doesn't feel comfortable, I guess, getting involved in that moment. This one is interesting. Mike and I have talked about this a couple times. A bystander can record or take notes on the harassment incident to benefit a future investigation. When I first read this, I found this pretty interesting because this is to me suggesting that, if someone's seeing something, you could pretty much whip out your smartphone and record it. So that to me was very interesting. A bystander could check in with the person who's been harassed after the incident, see how they are feeling, let them know the behavior was not okay. And the last example that the state is providing is that if a bystander feels safe, they can confront the harassers and name the behavior as inappropriate. And the state knows that when confronting harassment, physically assaulting an individual is never an appropriate response. I will file that under what Mike said earlier, which is maybe does not need to be said in terms of the policy. But to be clear, these are standard examples that the state has provided or standard methods for bystanders to intervene. I don't think it's necessarily limited to this. This is new for 2023, so we definitely wanted to point it out to you. And the state has acknowledged that although those examples are not exhaustive, they can serve as a brief guide of how to react when witnessing harassment in the workplace. And as we talked about it, the reporting obligations for bystanders are emphasized in the new policy as well. So Mike, I think I will go on mute, and I think you were going to pick up from here.
Okay, thank you. So, the one thing I do want to mention, the complaint form itself has not changed. We didn't attach the complaint form to this presentation. The state did not change that. Next, we're going to talk about what is sexual harassment. Not a lot of changes here as well. The general rule is it's a form of sex discrimination under federal law. Here in New York, it's its own form of protected activity in that things that should not occur. So to me, it doesn't matter. Federal, state law, it's discriminatory and illegal. Also, I want to warn you that this slide mentions local laws. Some of you live in locations where there are local laws that impact this area. So Onondaga County, City of Syracuse have discrimination laws. New York City, Albany County have discrimination laws. Tompkins County, City of Ithaca have discrimination laws. So just keep in mind, in addition to the federal and state component, there are out there local laws in that regard. The definition of harassment is extremely broad. It's including sex-based, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. I had 2 through 5 there in one case. The individual was a biological male, claims on certain days he was a female, claimed on certain days he was a little bit of both, and claimed on yet another day he was a male. He had a Facebook page to match every single one. And, at times, and his dress, let me just tell you a little bit, when he was a male, he, quote, dressed like a male. When he thought he was a female, he'd wear a dress to work. He was fired for threatening a supervisor and claimed afterwards, oh, no, you really fired me because of this. And, our response was hogwash, and the case was thrown out. So these cases do exist. They come at you in lots of different ways. Sexual harassment, a hostile work environment includes, but is not limited to words. I say something, signs. I hold up a sign calling you a sexually derogatory name. I didn't say it. It's still sexual harassment. Jokes always get out of hand. If you ever hear an employee saying to another employee, well, you're not offended by that, they never should have said whatever they said to begin with. Pranks, we have seen pranks escalate into sexual assaults. Very disturbing, some cases that have occurred, out there. Intimidation, people getting cornered, physical threats of violence. Now we're in criminal range. The test is, were they directed at the individual because of their sex in that regard? And that's what the plaintiff's attorneys try to prove. Location of the harassment. Most of this is was already here, but they added a little bit. I'll point that out to you. It's not limited to the physical workplace itself. Can occur with traveling. We just had a travel case that occurred. At employee-sponsored events, you know, the Christmas party, the softball game in the summer, or parties in that regard. Sexual harassment can also occur with calls, texts, emails, social media usage, even if they're away from work or after work hours and on personal devices. Let me give you an example. Johnny sexually harassed. Johnny's a great employee between the hours of 9 and 5. At 5:10, after work is over with, on his own phone, he starts sending nude photos of himself to a female employee. Is that harassment? Absolutely. Doesn't matter that it didn't occur at work. What matters is that there's a nexus to the workplace, that they're both employees in that regard. We had once a overnight delivery driver get smitten with a receptionist, followed her home. Well, that was a call to the cops, but it was also a call to the overnight company saying he's banned from our facility. This is what he did. And you may want to contact the cops to get the police report. That person we discovered was fired afterward. There's always something you can do. Please remember that. It can occur with working remotely. All right, we're now in this, are we coming out of a pandemic in that regard? They added this remote working part. They added the following: any behaviors that leave an employee feeling uncomfortable, humiliated, or unable to meet their job requirements constitute harassment, even if the employee or covered employee is at home when the harassment occurred. That's pretty broad. I'm not worried about the at-home part. It's this reasonable victim standard that you're starting to see here. Objectivity sort of goes out the window, and it's very subjective, the complaints of harassment that you might be dealing with. Could be inappropriate conduct on a Zoom call. We've all seen those horror stories where someone stands up and they have a tie on up top, and down below they're in their boxers. That's inappropriate conduct for a Zoom meeting, and the employee should be disciplined. So realize the at-home employee is treated the same as someone coming in. This is also new. Harassment can happen on a virtual meeting platforms, messaging apps, and after working hours between personal cell phones. I think they said that already, but they decided to add some additional language. There are two general types of sexual harassment: quid pro quo and hostile work environment. Very little change in the hostile work environment. I'll give you the additional thing in a minute. Quid pro quo, no change. There are two types of quid pro quo sexual harassment. What I put them in categories: reward or punishment. Sleep with me and I'll give you a $5,000 raise. It's still sexual harassment whether you capitulate or not. That's the reward type. Punishment. Sleep with me. No, you're fired in that regard. That's the punishment type. Either one is illegal. Quid pro quo we don't see as often as we do hostile work environment in that regard. The New York State standard is not severe or pervasive. That is the federal standard. So that just forget about it. Don't consider that if you're here in New York. You consider it when you're defending a federal lawsuit in that regard. The fact that the individual did not make a complaint about the harassment to the employer is not determinative. I don't think that's very fair to us. We're doing all this training, we're doing all this policy, but it's sort of irrelevant. It's a factor now to be considered. It used to be determinative in non-supervisory cases that the employee did not take advantage of a complaint procedure. That is no longer determinative here in New York. An employee doesn't need to demonstrate a comparator, someone to compare themselves to. It's sort of irrelevant in the world of sexual harassment here in New York. Now, here's your burden of proof. It's an affirmative defense, meaning you must prove it by a preponderance of the evidence, and that's a big deal in court. But I just want to say that to you. You have to prove this, that the harassing behavior does not rise above the level of what a reasonable victim of discrimination with the same protected characteristics would consider petty slights or trivial inconvenience. What's a petty slight? Flipping someone off in the workplace. You know, I'm doing training this afternoon, and I did training there about 4 years ago. And I said, do you all greet yourself by flipping each other off in the morning? They all laughed. That's how they greet each other in the workplace. I think that falls into the petty slight category. Maybe someone, have you ever sworn under your breath? You're really upset, you're mad at something. Yeah, I think that qualifies as well. The key is it has to be unwelcome in that regard. And one of the things I want you to tell your employees, you know, if you do the training or you bring a third party into the training, hey, speak up. If someone makes you uncomfortable, if someone puts their hands on you, tell them to knock it off. We see time and time again where that does not occur. Now, employees are sometimes, you know, I understand why it doesn't occur, but we have to empower our employees so that they tell us that first they tell the person doing it, knock it off, and then they tell us about it. And then we can do an investigation. So I've already explained quid pro quo, no changes there. Here is a change in the hostile work environment world that they added in that regard. Sexually oriented gestures, noises, remarks, or jokes, or questions. Now, that's a new one. Questions and comments about a person's sexuality, sexual experience, or romantic history, which create a hostile work environment. So I think if you, let's say you have someone who's transgender in the workplace, and the employee starts asking them questions about their status, inappropriate. It's crossing the line. So you need to be cautious of that. And they also just add, this is not limited to interactions in person. It can be made, you know, over the phone, face to face, by Zoom. It makes no difference to us. Another new thing that they added to the policy, sex stereotyping, which occurs when someone's conduct or personality traits are judged based on other people's idea or perceptions about how individuals of a particular sex should act or look. And you know, hey, guys don't dress that way. Well, why are you dressed that way in the work? That's a comment that's going to go too far and violate the policy. So, you know, they gave us some examples. And again, this is all new to the policy. Remarks regarding an employee's gender expression, such as wearing garment typically associated with a different gender identity. The case I mentioned to you where he had 3 different distinct identities. The client couldn't care less whether he wore a dress to a workplace. Not one day did anyone say anything about him other than complimenting him on the dress. And we actually got that out through some testimony in that regard. Asking employees to take traditionally gendered roles, such as asking a woman to serve meeting refreshments when it is not part or appropriate of her job duties. We see this in believe it or not, in highly male-dominated sales environments where the males who have been the sales people for much longer, make stupid comments or ask a junior salesperson who happens to be a female, hey, honey, can you go get us something to drink? Totally inappropriate and could potentially violate your policy and state law. Now, let me put that back. How about maybe it's the receptionist's job to do that and she happens to be female, or your assistant's job to ask her to do that? I think that's totally fine. I think it's when you stereotype and you assume, well, you're female, you're going to do this and I ask you to do it, that's where you're going to get in trouble. Those are the two big things that they added to the policy. The rest of what follows here in sexual harassment is really just a reminder to you. You know, it can be based on words, signs, jokes, pranks, intimidation, physical actions, or violence. Just like I said on the other slide, I like repeating that one. There's a laundry list of things it can be, and I've given you the laundry list here, things to watch out for. I would encourage you, depending on your workforce. I have clients that the first time I heard it was about 25 years ago. They did what, quote, porn sweeps of the workplace. They looked for anything inappropriate on a weekly basis. They took it down and they cataloged it. So it'd say, this is our due diligence and this is what it did. And you know what? We got to court. It helped us greatly in that regard. Not a bad idea, but it was a big workforce. So some of you are smaller, but you need to look for pictures, posters, calendars, pinup calendars, swimsuit calendars, the mail, the NDNY Fire Department mail calendar that they publish every year. Can't be up in the workplace, all right? It simply can't be. Graffiti, objects. This is the most unique object that I've ever had. You have the right in New York State to display the American flag. You can wear it at work on your lapel pin. I can have a little flag on my desk, and you as an employer can't tell me to take it down. So this guy was a real, you know, I'll call him a smart ass because he knew what he was doing. He brought in a dildo and put the flag on top of the dildo. Well, we made him take the dildo down, but he could keep the flag. He was saying we were violating his rights. Be careful of objects, all right? Make sure you know what they are when you take a look at an employee's desk. And if you're not sure, ask the employee, what is that? I think that's just good due diligence. Promotional material, reading material. I brought in Playboy or Penthouse. No, not appropriate for the workplace. Anything that's pornographic or sexually demeaning. No, not in 99% of the workplaces. Where's the exception for that? How about the porn shop? How about the strip club? How about certain bars? Yeah, there always are exceptions. Sexual displays on workplace computers or on cell phones? Absolutely not. Sharing those displays in the workplace with others or sharing videos in the workplace, totally inappropriate. Some examples here, you know, let me just get rid of, let me just see, I got a couple questions. Nope, I think we're all set on questions. Okay. Hostile work environment. Here's some more examples. It's basically, you know, you're doing something because of the person's sex. It's up to them to prove that. I typically assume it when I'm doing investigations. You interfere with, destroy their property, tools, or equipment. Well, how's that sexual harassment? Well, it's conduct directed at the person because of their sex, interfering with their ability to do the work, sabotaging an individual's work, bullying, yelling, name calling, all might be sexual harassment. Kissing, hugging, patting, or brushing against someone. Now, I don't think it's beyond the course of reality that a kiss or a hug in the workplace is inappropriate. I think you have to use common sense. My secretary is retiring next week. Do you think I'll give her a hug when she leaves? Absolutely, in that regard. Inappropriate? I don't think so in any way, shape, or form. Brushing against someone. You know, it happens at work. Let's be frank. Teach your employees to say, I'm sorry, excuse me, whatever it is. Patting, no, you know, totally inappropriate. We terminated an employee a few years ago. He didn't get the concept. You ever like tap someone on their shoulder to sort of tell them something? Yeah, I think that's appropriate. What he would do is he would tap them like in the groin level, and we wound up firing him for inappropriate conduct. Talking about your sex life at work, inappropriate. Repeated requests for dates, inappropriate. The first one's okay. No means no, and no playing hard to get. Obviously, we're escalating here. Sexual assault, inappropriate. Unnecessary touching, commenting on physical attributes, displaying sexually suggestive pictures or photos, inappropriate terms or epithets. A lot, there's a lot there. Continues indecent gestures, sabotaging, hostile physical conduct, emails, texts, Snapchat, social media, and the list could go on in that regard. It could be nonverbal, all right? It could be something that I bring into work. It could be something on my clothing, a tie. We had someone, the shirts, he brought it into the warehouse. I sleep well with others. We made him take the shirt off and disciplined him for wearing it to work in violation of the policy. Winking, blowing kisses, staring, blocking exits, sexual gestures. We had an idiot doctor during a surgery for, I think it was ACL. During the surgery, he had to manipulate the leg going back and forth. When he was manipulating it, the idiot started making sexually suggestive sounds. All three nurses complained about it after the surgery was over. Magazines, watch the Playboy, the Penthouse, assuming they even exist, but also watch other ones. I have a lot of problem with the Sports Illustrated swimsuit issue in most workplaces, Cosmopolitan, Glamour, things like that. People bring in jokes and cartoons and magazines. They think they're funny. Be cautious of that. Dress discussions, I think it's okay to compliment someone if they have a new hairdo or a new dress and you say that looks nice. I do. If you have nothing nice to say, don't say anything in that regard. We had a guy once that said that's a beautiful dress and had raindrops on it, and he's like, do you mind if I touch the raindrop? Ultimately, he was terminated. He was a little creepy and did something. Blonde jokes, all right. It's amazing. People still say, "Hey, we can do this." No, you can't. Not in the workplace. So I know that was a little quick, but most of it, just those first 4 slides, were new and updated. The rest of it was just a reminder. With that, I'll let Ari bring home the presentation with retaliation.
Thanks, Mike, and glad you put the blonde jokes on there. Those are not appreciated. I'll just throw that out there. Putting aside whether they're sexual harassment, I'm pretty much kidding. But as Mike said, we're going to bring it home talking about retaliation. I think a lot of us on the call knows what it is. An employee or covered individual that reports an incident of sexual harassment or discrimination, provides information, or assists in an investigation of sexual harassment or discrimination, even if they were just a witness, a bystander, they weren't directly involved. All of those types of individuals are protected from retaliation. I think we have to make it clear that no one should fear reporting sexual harassment if they believe it has occurred. So long as a person reasonably believes that they have witnessed or experienced such behavior, they are protected from retaliation. That's something new in the policy. There was an addition for 2023 to the model policy for a good faith belief. So as long as the employee who is reporting the alleged harassment had a good faith belief that it had actually occurred or that something inappropriate had occurred, they are covered by this and they cannot be retaliated against. And of course, if an employee, the policy is clear that if an employee believes they have been subject to retaliation, that they should report that to a supervisor or a manager. What is retaliation generally? Again, it's unlawful. It's action by an employer or a supervisor that punishes an individual upon learning of a harassment claim, seeks to discourage a worker or covered individual from making a formal complaint or supporting a sexual harassment or discrimination claim, or that punishes those who have come forward. This is important as well. Retaliatory actions don't have to be job related or occur in the workplace to constitute unlawful retaliation, much like discrimination or harassment doesn't necessarily have to occur in the workplace during work hours. So for example, threats of physical violence outside of work, disparaging someone on social media, those could all be potential examples of retaliation. As I mentioned before, this is new for 2023. If the harassment does not turn out to rise to the level of a violation, the individual is protected from retaliation if the person had a good faith belief that the practices were unlawful. But again, it's not intended to protect persons making intentionally false charges of harassment. The new policy has provided some examples of protected activity. I did want to stress that, you know, the mere intention to file a complaint, the mere intention or belief to do so is not a protected activity. That came up for me recently where we had somebody who was alleging they were retaliated against. And they said that the company knew that they intended to file a complaint somehow. And that because of that knowledge and the intent, they were wrongfully terminated. We ended up having good defenses to it. It ended up working out in the employer's favor, but it really needs to be one of these protected activity. Again, these are new examples that the state has proposed for 2023 and that were adopted. So protected activity occurs when a person has made a complaint of sexual harassment internally or with any anti-discrimination agency. So of course, it doesn't necessarily need to be an internal complaint. Has testified or assisted in a proceeding involving sexual harassment under the human rights law or other anti-discrimination law, opposed sexual harassment by making a verbal or informal complaint to management, or by just informing a supervisor or manager of the harassment. So it doesn't necessarily have to be a formal complaint again. Reporting that another employee has been sexually harassed or encouraged a fellow employee to report harassment. So these are new examples of things that could qualify as a protected activity under the new policy. The new policy has also given a much more robust discussion of examples of retaliation and things that could qualify for retaliation. There's obviously a wide range of examples. So we normally think of demotion, termination, denying accommodation, reduced hours, disciplinary action, things like that. The new policy also gives publicly releasing personnel files as an example. This is consistent with legislation that I think was passed toward the end of last year, basically saying that you cannot disclose an employee's personnel file in retaliation for them filing a complaint. So this basically just incorporates that legislation that was passed. Refusing to provide a reference or providing an unwarranted negative reference. Labeling an employee as difficult, excluding them from projects to avoid the drama. Got to be careful there because obviously with these types of situations, it makes sense in a lot of instances to separate employees, to move them around to certain projects, but have to be a little bit careful with that because we don't want that to come across in any sense as retaliatory in any fashion. Undermining an individual's immigration status or reducing work responsibilities, like passing over for promotion. I thought this was interesting, moving an individual's desk to a less desirable office location. So if you're looking at all the examples of retaliation in the new policy, it really is a pretty wide gamut of examples, ranging from termination to, you know, moving someone's office. You know, again, I've said this a couple minutes ago, the individual is protected from retaliation if the person had a good faith belief the practices were unlawful, even if the conduct is not substantiated following the investigation. I think that wraps up the presentation. We're only a couple minutes over, so I think that's good. Mike, I don't know if I want to turn it over to you. I'm looking in the chat. I'm not seeing any questions right now, but of course, anyone on the call, if you have a question, please feel free to jump on or put it in the chat.
Yeah, and while you're thinking, if you have a question, the biggest thing to walk away from today is the following. There's a new policy. We've given it to you. You need to implement it, distribute it to your employees, and have them sign off on it. Your training this year should be under the new policy in that regard, not the old policy, the new one in that regard. No change to the complaint form. The complaint form remains the same. You must have one. We strongly encourage you to make sure you're doing that training because if you don't, and if there is a claim against you, there will be a negative inference drawn against you because you're not doing a legal requirement in that regard. So be diligent. Make sure all your policies and procedures are up to date, but particularly this one. And please, please, please do the training in that regard, and you keep a record of it in case we're ever challenged on it. Ari, any last words? I see nothing in the chat, and then we'll turn it back to Beth.
Nope. Thanks, everyone.
I was going to ask if the New York State was updating their video training, but I did find it, so I will provide that link to everybody who's on this webinar as well when we send out the email with the link to this video recording.
Yeah, and there is a new video, and there is a new, some more additional frequently asked questions that some of you may find helpful as well. I would warn you, you can look at training in one of two ways. We're just going to show the state's video every year, and that's it. It's a check the box. Okay. Your employees, after a year, the second time they watch it, they're going to say to you, didn't we just see this? We recommend, but it is not required, that you rotate the training. One year you use the state's video, next year you bring in someone maybe internally to do it, then you bring in someone externally, and then maybe go back to the state's video. I think it's a way to hear different perspectives, and it helps employees if you really want to give them the educational piece in that regard.
All right, thank you again, everyone, for joining us today. Next week is Small Business Week, and we have a jam-packed educational series based around small businesses. So please take a moment and go to chemungchamber.org to register for these upcoming educational series or see any of the other events we have scheduled for Small Business Week. You can also find recordings of previous webinars. Many thanks to Michael and Ari, and to everyone for joining us today. Have a good day.
Thank you.
Thank you.